I'm Jackie Clary. I'm president of the Coos County League, and I wanted to welcome our two circuit court judges or judges. And honorable, that was a word I was supposed to remember, and I forgot. Okay. I have a little short information about each. And didn't put my glasses on, so we'll see. And first of all, I need to know how to pronounce your last name.
Jacquot.
Jacquot. So Megan Jacquot. This is Megan. Um, is grown up in Oregon, has been an Oregonian her whole life. I think I've got allergies that I've never had before, so I'm not speaking clear. She graduated from Pacific Lutheran University and Tulane University Law School. She and her husband moved to Coos Bay in 2000 and raised their 5 children here. After spending 5 years at Southwestern Oregon Public Defender's Office, she opened her own law office specializing in juvenile law in the trial courts of Coos, Curry, Douglas, and Josephine counties, and statewide appellate courts. She served for many years on the North Bend School Board, and she was appointed to the Oregon Commission for Women in 2007. I may be voiceless by the time I get to you. In 2015, she was elected to the Coos County Circuit Court Judge as a Circuit Court Judge. She served for 7 years in that position. In 2022, she was appointed to fill a vacancy for the Oregon Court of Appeals and was reelected to that position in 2024. She currently splits her time between Salem and the Coos Bay area and serves the Judicial Department on the Oregon Supreme Court Council on Inclusion and Fairness, the Judicial Leadership and Education Committee, and the Judicial Representative on the Governor's Child Foster Care Advisory Commission. And in her spare time, she loves to read, cook, travel, and fish, right? Welcome. And now, yours is the Duke fish. This is Circuit Court Judge Martin Stone, and he graduated from Myrtle Point High School down the street from me, Willamette University, and the University of Oregon Law School. Was attorney in private practice in Coquille for 19 years, handling a broad range of civil and criminal cases. Appointed by the governor to the position of Circuit Court Judge for Coos and Curry counties in February of 1998, and was elected each term since, every 6 years. Yeah, I was counting that, yeah. He served as the presiding judge of the circuit courts in Coos and Curry County. He's doing that now, right? As a circuit court judge, Judge Stone has presided over criminal, civil, juvenile, and family law cases in Coquille, Gold Beach, and other judicial districts in the state. Judge Stone is a member of the Oregon State Bar and the Coos Bar Association. He is also a member and past president of the Coquille Rotary Club and the past president of the Coquille Chamber of Commerce. He was also associate editor of the Oregon Law Review while in law school and has authored articles on law-related subjects and is a speaker at meetings and events in this community, such as this one. All right, thank you. And this is Judy Moody, who is going to be our moderator. Aren't you? Is that
Yes, chairs are so weird. They're rocking chairs. Yes, okay, so thank you for coming. Welcome from the league. And I have a few little housekeeping items to talk about. Oh, closer to my mouth. You have question slips. If you don't have question slips, please hold your hand up if you want to ask a question. And one of the pages will bring you a slip and a pencil. And during the judge's talk, if you think of a question and you write it down, just hold the question slip up and the pages will bring the questions over here to our screeners, because the questions will be screened. There could be duplicates, and maybe your question won't be asked, but somebody else's that's just like yours will be asked. The screeners will then go through the questions and then bring me the questions to ask the judges at the question and answer period after they speak. Okay? And I do have a few question guidelines. The question guidelines for this event are as follows. The Oregon Code of Judicial Conduct requires that judges act in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Judges are prohibited from commenting on pending cases or cases and issues that may come before the court in the future. Judges may not answer questions that seek advisory opinions or that involve political issues left to the other branches of government. Judges are prohibited from answering questions that announce their beliefs or on disputed legal or political issues that are best left to other branches. The judges cannot answer any questions or make any comments that would affect cases that they have pending or cases that will likely come their way or offer advisory. It's dead, but I think I can project. Offer advisory opinions. Any such comments are prohibited by the Oregon Code of Judicial Conduct. The League will not accept any questions regarding immigration, deportation, use of ICE, use of force, protests, deployment of the National Guard, and whether those actions violate the Constitution. Thank you for your respect during this event. And now I'll turn it over to the judges.
I think I'll take the lead if that's so. I told Jessica I'll take the lead and give you some thoughts. First thing I want to say is I want to thank the League for inviting us to be here today. I truly enjoy getting out when I can get out to talk to folks about what's going on in the courthouse and what we do as judges, at least in the trial level. I frequently accept invitations to go out and meet with groups and share thoughts and ideas, not about specific cases, but just generally what's going on in the courthouse. So I truly appreciate the invitation, and I hope I can come back again one of these days. If I don't, wear out my welcome today. The other thing I want to underscore is what Judy read, that information about what we can and can't do up here today. We're not trying to duck questions, but we subscribe to the Code of Judicial Conduct that prohibits us from commenting on cases that we have underway or issues that we may have in the future, or giving advisory opinions or commenting on what the executive branch is doing. Those types of things we can't do. So don't feel like we're trying to duck the questions intentionally. We just can't talk about that. We get in trouble if we do. So please don't hold that against us. I want to give you a bit more information about me and then segue into a few comments about the Constitution, how important that is. I am a circuit court judge. That was mentioned earlier. I am one of about 181 circuit court judges around the state. I am a state court trial judge, which means I work in the courtroom. I deal with people day after day, litigants that have issues presented to a judge or a jury. And that's what I do on a daily basis. For those of you that may not know, we are in what's called the 15th Judicial District of the state of Oregon. Oregon's been carved up into 27 judicial districts. Ours is the 27th or 15th Judicial District, which covers Coos and Curry counties. So when you say that I'm a judge in the 15th Judicial District, I am one of the judges in the two counties. We have 6 circuit judges that work in our judicial district. 2 of us work in Coquille. It's right, 4 of us in Coquille. How quickly I forget. And two of my judges down in Curry County. Gold Beach has the courthouse. Coquille has the courthouse. 4 in Coos County, 2 in Gold Beach. But that's our judicial district. We are trial judges. Again, we handle cases face to face with people in the courtroom. We are open to the public. We handle our cases open to the public. We do all types of cases, from the most serious cases, the murder cases, the person-to-person cases, the sex cases, the juvenile cases, the abuse cases, the termination of parental rights cases, all the way down the line, civil cases, domestic relation cases, small claims cases, FED cases. The list goes on and on and on. The decisions we make, or that I make as a trial judge, are recorded. And it's important to understand that everything we do in terms of rulings is being recorded. If an individual doesn't like our decision, they can appeal my decision or our decisions to the Court of Appeals, where Judge Jacquot sits. She then and her group of judges review the record on what was done at my level, the trial level, and determine whether or not there was an error made in the law or maybe some factual issues, and either reverse or affirm our decisions. So again, what we do is not the final word. If an individual wants to appeal, they can appeal that to the next level. Now, I don't profess to be an expert on the Constitution, either the Oregon Constitution or the U.S. Constitution, but I can tell you that as a trial judge, we deal with constitutional issues on cases that come before us. And I'll give you a few examples in a few moments. The constitutions that we deal with include both the Oregon Constitution, which was, I think, 1857, it came into play, and the U.S. Constitution, ratified, as I recall, 1789. So on the cases that we hear at the trial level, it's not unusual for a defense lawyer to raise issues on whether or not what the government has done runs afoul or violates the Constitution. So we see those in the courtroom on the cases that we handle. Now, we all went to high school. We probably all remember what we learned in our civics classes, but the Constitution is critical. The constitutions, both at the state level and the federal level, they set forth the system of our governance. They create, the constitutions establish the 3 co-equal branches of the government, the executive or the legislative branch that actually makes the laws, the executive branch that executes the laws, and the judicial branch where Judge Jacquot and I sit. We interpret the law and we apply the law. That's the functions of each of the separate branches. The constitutions, you may remember, define the powers of each of the branches. The Constitution sets forth some checks and balances to make sure one branch doesn't exceed the powers that are vested in that branch. And most importantly, from my perspective, in the cases that I deal with, the constitutions on both the state and federal level set forth what's the rights and the liberties and rights of our individuals, the Bill of Rights, what freedoms we enjoy, what rights we have, what rights the government cannot intrude upon. So as a trial judge, I oftentimes, quite frankly, deal with issues that arise out of the Bill of Rights. Lawyers will raise issues on things such as search and seizure issues. Has the government gone too far in collecting the evidence? Has the government gone too far in taking statements from individuals? Is the sentence that I've imposed cruel and unusual? Is the individual being denied speedy trial? All those types of rights that are guaranteed in the constitutions generate some issues that I see in cases that I hear probably on a weekly basis. What's interesting, and I'm stealing Judge Jacquot's time here, but what's interesting is if you look at the Bill of Rights that appear in the Oregon Constitution and the Bill of Rights that appear in the U.S. Constitution, many of those rights overlap. If you look at first 10 amendments to the U.S. Constitution sets forth the rights such as freedom of expression, freedom of religion, protection against unreasonable search and seizures. All those rights are part of the first 10 amendments. But then if you look at the Oregon Constitution, Article 1 of the Oregon Constitution has about 47 sections, each of which identify rights that are guaranteed of our citizens. And many of those rights overlap. In fact, most of the rights overlap with what's in the U.S. Constitution. And I oftentimes will see those issues raised by lawyers, both under the Oregon Constitution and the U.S. Constitution. Now, I see a variety of issues raised by lawyers over the years. I've seen many, many issues. I've seen challenges to search and seizures, where the lawyers are arguing that the individual that entered the house, that was an unreasonable search and seizure. I see many, many challenges from statements that individuals have made to law enforcement without being told what their rights were. I see challenges where individuals don't like the sentence that I impose and argue that it's cruel and unusual, and I have to evaluate that. I see frequently cases where I've ordered what's called a Measure 11 sentence, which is mandatory prison of maybe 70 to 90 to 120 months. And lawyers will raise issues on whether that's cruel or unusual. Has what the legislature passed, has that created something that's cruel or unusual? So we see a variety of these cases at the trial level. I do my best to make rulings on these. And then I look to the Court of Appeals to give me some guidance if I've done something wrong. I would tell you one final thing, and when I evaluate these issues that come across in my courtroom, and I'm trying to decide whether or not what the government has done violates the Constitution, I look first at the language of the Constitution. What does it say? What does the text say? Read the language and try to understand what the meaning is. I then can look at things like the history of how that language was created and the circumstances that existed when that language was created. What did the framers intend by that language that appears in the Constitution? And most importantly, if I still don't know, I can look at decisions from Judge Jacquot in the Supreme Court that we call precedent, because what they decide at the appellate level is put in written form, becomes a precedent that I as a trial judge can look at in the future if I have those issues. So if you see me looking at books in the courtroom, I'm looking at decisions from Judge Jacquot and the Court of Appeals in determining what they thought that language, what they know the language means, and how I, the trial judge, should apply that language. So that's a lot of information. I probably motor mouth too much. I'm going to defer to Judge Jacquot, and then I'm open to some questions.
No, he did a great job kind of explaining the system. I'm a Court of Appeals judge. There are 13 of us in the state, and what we do is here, we're an appeal of right court. So every case that comes out of the circuit courts anywhere in Oregon has a right to appeal, to go to the Court of Appeals to have their case evaluated to determine whether the government oversteps its bounds in some way. And we analyze those things. Above us is the Supreme Court. There are 7 individuals on that court, and they are primarily a law-giving court. Their function is they get to choose what cases they take. We have to take every case that comes to us, and so we're very busy in evaluating a lot of cases. Court of Appeals has 2 different functions. One is error correcting. If there's a problem that somebody's rights weren't upheld during the trial stage, we'll correct that or send it back to get it to be done again. But also a law announcing court. At some point, we have to start with interpreting the constitutional provision or statute at issue to determine what it means. And then those often go to the Supreme Court. And if they haven't yet announced what the provision means, they can decide to take our cases, change what we did, and then publish it. And then the trial court judges and the Court of Appeals are required to follow their decisions. So we end up doing constitutional issues every day. Like Judge Sohn was saying, they address constitutional issues all the time, but everything that we do is built on constitutional principles that set up the relationship between the citizens and their government. A lot of what we do is state in federal of rights in order a lot of things where five or six cover what is one piece of the Bill of Rights in the 10 in the federal government. So with regard to like freedom of religion, the first six of our Oregon Bill of Rights sections cover the freedom of religion. The Establishment Clause and the Free Exercise Clause is broken up into various different sections. Same thing with cruel and unusual punishment. It's broken up into proportionality, whether you're treating people the same with regard to when Judge Stone is deciding to impose a sentence. We have one provision to talk about that, and one provision to talk about how we treat people who are incarcerated, and that we don't treat them with unnecessary rigor, that we have different functions of the criminal justice system. And so those are all outlined in the Constitution. Let's see. There are certain, because we independently interpret our Oregon Bill of Rights, there are times when you have both an Oregon right and a federal right about the same situation. Sometimes we interpret our provisions differently, and so you would have a different right under the federal constitution and the state constitution. That happens a lot in search and seizure issues, and so it matters what the attorneys are arguing. If they're arguing under the federal constitution, they may have a different scenario about whether the person is seized or not than you would have the answer under the state constitution. And so that can get a little bit tricky. But a lot of what we do with state courts, we look at first the state constitution and evaluate whether that can answer the question. And we don't sometimes ever get to the federal constitution. There's been an issue with the federal Supreme Court looking mostly to kind of the status quo at the time the Bill of Rights was adopted. They look back at the original intent. That's not what we do in Oregon. We try and apply our constitutional principles to modern day circumstances and determine what the answer would have been if you apply those principles faithfully to the new situation. So the Oregon Constitution is meant to grow over time, and that's the way that we interpret it. That's especially interesting now, since the federal government, the federal Supreme Court has been abandoning precedent. We're supposed to follow their interpretations with regard to the pieces of the Constitution. Some of the analogs, we treat them exactly the same as the federal situation, but some of our constitutional provisions, we interpret them differently. And in those cases, a lot of times our constitution is going to give you more rights than you would have under the federal system. The federal constitution is meant to be the floor, which the states can't go below. But the state can always give more rights than the federal constitution does. And there are a couple of situations we'll talk about where that happens here.
Yeah, I was going to take a moment and tell you some of the types of cases that I see on the trial level. Defense lawyers frequently, especially in criminal cases, defense lawyers frequently file motions to suppress. An example would be if there is a search of a residence, finding some drugs inside the residence. They oftentimes will file motions to suppress, claiming that that search was unreasonable under the Constitution, that the officers had no right under the Constitution to actually enter the house, to search for the drugs. So I have to analyze that, and analyzing means that I look at what the Court of Appeals has said on some of those issues. Look if the Supreme Court has taken up that issue, look at the state Supreme Court rulings, and decide based upon that whether there's been unreasonable search and seizure. I see that a lot in terms of searching residences or searching persons, stopping somebody on the street, seeing their bag, opening up their bag. Is that considered to be unreasonable search and seizure? So I see that frequently. I see cases involving, I mentioned this earlier, cruel and unusual punishment. I see individuals arguing that what I've ordered is beyond what should be ordered. It constitutes cruel and unusual, especially in the neighborhood of these Measure 11 sentences. I have many cases that I have that involve Measure 11 crimes, in which the individual may have 2 or 3 convictions for Measure 11 sentences, each of which might carry a sentence of mandatory 75 months in prison. And they could be consecutive sentences. So I may well order that the 3 convictions run consecutive for a total of a whole bunch of time in prison. And the argument would be that that's cruel and unusual, which is not, according to the rules of the Court of Appeals, and probably the Supreme Court too. So I see that. I see issues, speedy trial issues, the constitutions at the state level and the federal level guarantee a speedy trial. If you're charged with a crime, you're entitled to a jury trial and a speedy trial. And the question becomes, has the process delayed to the point where the individual is denied their speedy trial rights? And that comes up in situations where there's been a delay in getting the case tried to a jury, and during that delay period, there's been loss of evidence. So the defense is prejudiced by having the delay, and they're no longer able to have a fair trial. So that cases comes up from time to time. Ineffective counsel comes up a lot these days. The Constitution guarantees rights of the accused, including the right to a lawyer, an effective lawyer. And the cases that I see from time to time, not cases, I see inmates in the jail that are complaining about the performance of their lawyer. Did the lawyer performance fall below the standards that we hold lawyers to? So ineffective counsel comes up. Right to a jury trial comes up from time to time. I have cases where the individual is asking for a jury trial, but under the law, they're not necessarily entitled to a jury trial. Those issues from time to time come up. Habeas corpus comes up from time to time on my level. Habeas corpus, I know Judge Jacquot touched on this briefly. Inmates in jail will question whether or not they're being denied some rights over in the jail, medical attention. Are they being held beyond what the sentence was ordered by Judge Stone or one of the judges? So that comes up from time to time, habeas corpus as an issue. The remedy clause, we have remedy clauses in the Oregon Constitution. Denial of an adequate remedy, we see that from time to time. Individuals that may have had an injury at work that's covered by workers' compensation, they want a jury trial, to have a jury trial decide the case, and the issue is, are they being denied a remedy by going through the workers' compensation process as opposed to a jury trial? And then I mentioned earlier, I oftentimes get lawyers that are concerned about statements their clients have made to law enforcement without being advised of their rights. People have the right not to incriminate themselves, and oftentimes, not often, sometimes they make statements that they should have made that the state wants to use against them later. So all those types of issues come up. It keeps me very busy on a daily basis, but I do look at the Court of Appeals and the Supreme Court for guidance on these issues.
Just a shout out to the trial court judges. I did that job, and it's incredibly difficult to make all these decisions in the short time that they have to make it. There are days when Judge Stone will have 4 or 5 different motions to suppress to decide in one day, and he'll have to look at different searches and Miranda issues and make all those decisions on the basically on the flip of a coin. He's got a lot of information in his head, and so he's looking at the statutes, trying to remember what he knows about all of the cases. But you don't have time as a trial judge to go back and look up the answer to everything. That's one of the things that I think is really nice about working on the Court of Appeals is we have time to look up the answer and make sure that what we say is consistent with everything we've already said, what the Supreme Court has said, and make sure that we think we have the right answer. It's incredibly hard to do that in front of people in a trial with a courtroom full of people and sometimes a jury watching to make those decisions. The way that we handle the cases that come from them is we look at the record and try and determine, for instance, in a search issue, that's one of the interesting issues where Oregon and the federal rights are treated differently. There's a rule in federal court that you can't extend a traffic stop. You have to have reasonable suspicion that a traffic stop has been committed in front of the police officer or probable cause to believe that a crime has been committed. And when you are analyzing the search issue, you have to look at whether the police officers unlawfully extended the time that it would take to issue a ticket to somebody based on the reason that you stopped them. And if they extend it for longer, then under the federal analysis, that's something that can be problematic, and you could end up having the evidence that came after they unlawfully extended the stop suppressed. That's why a lot of it's important is we have what's called the exclusionary rule, which is that the government doesn't get to profit from trampling on people's rights. And so what they'll do is keep that evidence out of a trial, and the state won't be able to use it to prove that a crime occurred. And that's why those searches are litigated so much on the front end. But in state analysis, we also have a subject matter limitation that in addition to not making the stop longer than it needs to be, the police also are not able to switch topics with regard to what they're asking the citizen about. So a lot of times under federal analysis, they will stop them for a traffic issue, but then they'll run a drug dog around the car. And if that doesn't take longer than it would take to issue the ticket, for instance, if you have 2 officers there, that wouldn't be a problem under federal law, but under Oregon law, it is, because they're inquiring about the possession of drugs or something unrelated to the reason that the person was stopped, say expired tags or things like that. So you have to look at both, and it does matter what the attorneys are arguing. So it's very complicated. With regard to sentencing issues, again, we look at proportionality when we're trying to determine whether a sentence is constitutional or not. We're considering both the person's criminal history, the related sentences for similar conduct, that we have lots of crimes that can be more than one thing. So we look at the behavior and what courts do under similar types of conduct in order to determine whether the sentence is proportional or too long, with regard to trying to treat everyone fairly. And then we're also looking at what the sentencing guidelines propose for each one. It's really hard to prove that a sentence is disproportionate under the Constitution, that the person's been treated unfairly, but it's a lot of applying those constitutional principles to new crimes as they come up and get developed. So as Judge Stone is keeping it in his head when he's on the bench trying to decide what to sentence people to, we have to work in all of those things. Plus, consider things like you're supposed to there's part of our Constitution that says you can't restrict the ability of a court to sentence consecutive sentences for when there's more than one victim of a crime. So there are default rules that typically when you're sentencing somebody and it's all part of the same act or transaction, you have to sentence them to concurrent sentences rather than on top of each other. A lot of times people will do a bunch of things at once, like possess drugs and possess a weapon and various things like that. But if it all happens at once, the court has to decide whether to sentence them back to back or on top of each other. Inadequate assistance of counsel is one of the things that we've decided that the Oregon law is going to be treated exactly the same as the federal law. So the test we apply is the same whether they're arguing that it's inadequate assistance under the federal constitution or under the state constitution. So that's one of the weird ones where it comes out exactly the same. Right to a jury trial. We had a case where somebody was arguing that they had a right to a jury trial on a probation violation last week. And we have to determine whether that's something that there's been a case law for a long time that you're not entitled as on a probation violation to have a jury determine whether you violated your probation or not, because you already had the right to that jury trial when you were convicted of the crime in the first place. But those things come up from time to time. People are trying to extend what each of the Oregon provisions means. I had one where they were trying to argue that Article 1, Section 11 actually did provide the right to a jury trial on the probation violation. So we had to decide that in the first instance. The Supreme Court has never looked at it, so now they took it based on our opinion, and they're trying to decide whether that actually means that you have more rights in Oregon than you do under the federal constitution. Let's see, habeas corpus, we see a lot of those based on conditions of confinement. I know that that's an interesting one because in the circuit courts, they're usually defended not by the district attorney, but by the county attorney. So judges will be, habeas corpus is a civil issue, so it's attached to a criminal case because people are confined based on the criminal case, but you're applying the civil rule to determine whether they are unnecessary rigor or that the state is being deliberately indifferent to the needs of the person that's incarcerated. So we do a lot of habeas at the Court of Appeals too, in determining whether the court was right. I remember one of my favorite habeas cases I ever worked on was a person with a back injury. This counties don't like to incarcerate people with a lot of expensive medical issues because while they're in jail, the county has to pay for all their medical treatment. So we had a habeas case and we ended up getting the person a second mattress because they couldn't sleep on the jail has like concrete slabs with a little 2-inch mattress on top of it, and it was aggravating his injury and it was expensive. So the court ended up figuring out that the way to redress that and not be too rigorous on this person was to get them another mattress. So I won, but it didn't feel like too much of a victory. He wanted to be out of jail because of that, but that didn't work. So he got a remedy, but it wasn't the remedy he was looking for. Let's see, Miranda issues. Miranda issues is one of the things that Oregon gives you a lot more rights than you have under the federal constitution. The federal rule is that if you're in custody and you're being interrogated, asked questions by the police, you have to be informed of what your rights are. The right that you don't have to incriminate yourself. You don't have to be forced to answer questions. And that you also have a right to counsel to help you with the interrogation and to help you with the trial and the critical stages of the trial. In Oregon, we interpret that also to mean compelling circumstances, not just if you're in custody. So you don't have to be actually in the police station or in the jail being questioned. You could be in a police car or in your own car being questioned, but the police have boxed your car in so you can't move or get away. Those sorts of things in Oregon, you'll be able to be required to be given your Miranda rights in order for them to use any statements that you make. Otherwise, those statements can be excluded. So attorneys, smart attorneys, will argue under the state constitution rather than the federal constitution for the same issues because they're much more likely to have that evidence suppressed. So as a trial judge, you have to really look what they're arguing because the answer could be completely different under federal and state constitutions. So I think that deals with the way that we handle all of the things that Judge Stone had talked about.
I think that's it, Judy.